You are standing in a field outside Philadelphia in the spring of 1776, and the air smells of turned earth and gunpowder residue carried on the wind from somewhere you cannot see. The Continental Army is forming. Men are gathering in towns and villages across the colonies, some eager, some reluctant, all answering a call that has begun to sound less like invitation and more like command. But here, in this field, there is a group of men who will not go. They are Quakers, mostly, some Mennonites, a few Brethren. They wear plain clothes, grays and browns, fabrics without ornament. Their hats are simple. Their faces are weathered from farm work, not war. They stand together, not defiantly, but quietly, with the kind of stillness that comes from certainty rather than fear. A militia officer approaches. He is young, perhaps 23, with a uniform that still looks new. He carries a list of names. He calls out the first one. The man steps forward. He is middle-aged, with hands that have held plows and children, but never a musket. "You are summoned to serve," the officer says. "I cannot," the man replies. "Cannot or will not." "Both," the man says. "My faith forbids it." The officer looks at him for a long moment. The law, such as it is in this moment of revolution, does not have a place for this. There is no form to fill out, no exemption to claim. There is only the need for soldiers and the presence of men who will not become them. "You'll be fined," the officer says, "or imprisoned, or both." The man nods. He has expected this. "I understand," he says, "but I cannot take up arms, not against the king, not against anyone." The officer writes something on his paper. He moves to the next name. This scene repeats itself in different fields, in different colonies, in different wars, across centuries. It is always the same essential moment. The state requires violence, and the individual says, "I cannot." But the law does not yet have a name for this refusal. It does not yet have a doctrine, a test, a standard. It has only consequences: fines, imprisonment, public scorn, the seizure of property, sometimes death. The words conscientious objection do not exist in American law in 1776. They do not exist in 1812 or 1846, or even at the start of the Civil War. What exists instead is a patchwork of local accommodations, of grudging tolerances, of communities that know certain families will not fight and have decided, sometimes, to let them pay money instead, or to let them serve in other ways, carrying supplies, tending the wounded, digging graves. But this is not a right. It is a mercy, and mercies can be withdrawn. You are standing in that field, watching these men refuse, and you are witnessing the beginning of a question that the law will spend the next 2.5 centuries trying to answer. What does a government owe to the person who cannot, in good conscience, kill? You are standing now in a courtroom in Brooklyn, New York, in the year 1917, and the room is smaller than you expected. The windows are tall but narrow, letting in only thin columns of spring light. The air is close. There are perhaps 40 people in the gallery, most of them young men, most of them looking uncertain about why they have been called here. The United States has entered the Great War. The Selective Service Act has just been passed. For the first time in American history, the federal government has asserted the power to draft men into military service on a massive scale, and for the first time it has included, buried deep in the text of the statute, a provision for those who object. Section 4 of the Act reads, Nothing in this act shall be construed to require or compel any person to serve in any of the forces herein provided for, who is found to be a member of any well-recognized religious sect or organization at present organized and existing, and whose existing creed or principles forbid its members to participate in war in any form. The words are careful. They are narrow. They say, if you belong to a church that has always opposed war, and if that church is recognized, and if you were a member before this war started, then perhaps you will not have to kill. But they do not say what happens if your conscience objects, but your church does not. They do not say what happens if you came to your convictions on your own, through reading, through prayer, through the quiet accumulation of moral certainty that does not fit neatly into any denomination's creed. The man standing before the judge today is named David. He is 22. He is not a Quaker, though he has read their writings. He is not a Mennonite, though he respects their witness. He is, he says, simply a Christian who has come to believe that Jesus' commandment to love one's enemies cannot be reconciled with shooting them. The judge looks at him with something like frustration. You are not a member of any recognized peace church, the judge says. No, Your Honor. Then you do not qualify for exemption. But I object, David says. I object conscientiously. The judge pauses. The phrase is not in the statute, but it is in the air. It has been said in other courtrooms, in other hearings, by other young men trying to articulate why they cannot comply. The law has not caught up to the language, but the language is forming anyway, in the mouths of those who need it. Your objection is not recognized, the judge says. You will report for duty. David does not report. He is arrested. He is tried. He is sentenced to military prison, where he will spend the next 2 years in conditions that break some men and harden others. He is one of thousands, some estimates say as many as 20,000 men, who refused service in World War I. Some were granted exemptions, many were not. The law was unclear, inconsistently applied, dependent on the temperament of local draft boards and the patience of military tribunals. But something has begun. The phrase conscientious objection is entering the legal vocabulary. It is being spoken in courtrooms, written in court opinions, debated in law reviews. It is becoming a concept, even if it is not yet a right. You are watching this moment, and you are seeing the law struggle with a problem it has always struggled with: how to respect the individual conscience without undermining the collective need, how to allow dissent without inviting chaos, how to honor deeply held belief without letting belief become an escape hatch for cowardice or convenience. The law does not yet have answers, but it is beginning to ask the questions. You are standing now in the Supreme Court of the United States in Washington, D.C., in March of 1965. The courtroom is grander than the one in Brooklyn. The ceilings are higher, the marble is whiter. The air itself seems weighted with the importance of what happens here. The case is United States versus Seeger, and it will change the meaning of conscientious objection. The young man at the center of this case is named Daniel Seeger. He is 25, soft-spoken, thoughtful. He has refused induction into the Army, and his draft board has denied his claim for conscientious objector status. The reason? He does not believe in God. The statute, as amended in 1948, allows exemption for those whose objection is based on religious training and belief, which it defines as belief in a relation to a supreme being involving duties superior to those arising from any human relation. Seeger does not claim belief in a supreme being. He claims instead belief in goodness and virtue for their own sakes and a religious faith in a purely ethical creed. He has been influenced by Plato, by Aristotle, by the Stoics. His objection is philosophical, ethical, deeply sincere, but not, in the traditional sense, theistic. The government argues that he does not qualify. The statute says supreme being. Seeger does not believe in one, therefore no exemption. Justice Tom Clark is writing the opinion for a unanimous court, and he is trying to find a way through this thicket. The court knows that if it reads the statute literally, it will exclude many sincere objectors whose convictions are as strong as any Quakers, any Mennonites, any Catholic pacifists. But the court also knows that if it reads the statute too broadly, it will open the door to objections based on political philosophy, personal preference, mere distaste for war. The opinion, when it comes, is an exercise in careful interpretation. Justice Clark writes, "The test of religious belief within the meaning of the exemption in the draft law is whether it is a sincere and meaningful belief, occupying in the life of its possessor a place parallel to that filled by the God of those admittedly qualifying for the exemption." Read that again, slowly. Let it settle. The court is saying, we will not require belief in God, capital G. We will require belief in something that functions like God, that commands ultimate loyalty, that imposes moral obligations, that cannot be ignored or set aside for convenience. This is a profound shift. The law is moving from requiring membership in a recognized church to requiring only sincerity and depth of conviction. It is expanding the circle of who may claim conscience, but it is also preserving a boundary. Your objection must be like religious belief, even if it is not, strictly speaking, religious. You are standing in the courtroom as Justice Clark reads this opinion, and you are hearing the law stretch itself to accommodate a new understanding of conscience, one that fits a more pluralistic, more secular America, one where people find moral truth in many places, not only in Scripture. But the stretching is not finished. You are still in the Supreme Court, but the year is now 1970, and the case is Welsh versus United States. Elliot Welsh is another young man who has refused induction. His objection is even more clearly non-religious than Seeger's. On his conscientious objector form, he struck out the words religious training and belief, and wrote that his objection came from reading in the fields of history and sociology. The draft board denied him. The lower courts upheld the denial. The Supreme Court reverses. Justice Black, writing for a plurality, says that Welsh qualifies. His beliefs, though not religious in the conventional sense, are held with the strength of traditional religious convictions. That is enough. But Justice Harlan, concurring, goes further. He writes that the statute, if it distinguishes between religious and non-religious conscientious objection, violates the Establishment Clause of the First Amendment. The government cannot prefer religious objectors over non-religious ones. If it grants exemptions for conscience, it must grant them to all sincere conscientious objectors, regardless of whether their objections are rooted in faith or philosophy. This is the high water mark of conscientious objection doctrine. The law has come to say, if you sincerely believe, based on moral or ethical principles central to your being, that you cannot participate in war, then the government must exempt you from the draft, even if your beliefs are not religious. But then the water recedes. You are standing now in the same courtroom, but the year is 1971, and the case is Gillette versus United States. Guy Gillette is a different kind of objector. He does not object to all wars. He objects to this war, the Vietnam War, which he believes is unjust. His objection is selective. He is willing to fight in a just war, a defensive war, but not in what he sees as an immoral war of aggression. The Supreme Court, in an 8-1 decision, denies his claim. Justice Marshall, writing for the majority, explains that the statute allows exemptions only for those who oppose participation in war in any form. The law, he writes, cannot allow individuals to pick and choose which wars they will fight in, because that would require courts and draft boards to adjudicate the justice of particular wars, to weigh political and moral arguments about foreign policy, to become entangled in questions that are beyond their competence and authority. The law draws a line. You may object to all war based on conscience, but you may not object to some wars and not others. That is politics, not conscience, even if your political objection is as deeply felt as any religious one. This is the paradox of conscientious objection doctrine. It is both expansive and narrow. It has expanded to include non-religious objectors, but it has narrowed to exclude selective objectors. It honors conscience, but only a certain kind of conscience, absolute, categorical, unwavering. You are standing in the courtroom, and you are seeing the law make a choice. It will protect the pacifist, but not the just war theorist. It will exempt the person who says, "I cannot kill," but not the person who says, "I cannot kill in this war for these reasons." And you are left wondering whether this is wisdom or cowardice, whether the law has found a principled line or simply an administratively convenient one. You are standing now not in a courtroom, but in a recruiting office in a small city in Ohio. The year is 2004. The war in Iraq is in its second year. The office is sterile, fluorescent lights, linoleum floors, posters on the wall showing soldiers in clean uniforms doing noble things. A young man walks in. He is 19, maybe 20. He enlisted 2 years ago, right out of high school. He has been to basic training. He has been to advanced training. He has not yet been deployed, but his orders have just come through. He will ship out to Iraq in 6 weeks. He sits down across from a sergeant and says, "I want to apply for conscientious objector status." The sergeant looks at him for a long moment. "You're already in," the sergeant says. "You signed a contract." "I know," the young man says, "but I didn't understand. I didn't know what war was. Now I do, and I can't do it." The military, unlike the draft, does not easily accommodate conscientious objection. The regulations allow for it, but the process is arduous. The applicant must prove that his beliefs have crystallized after enlistment, that they are sincere, that they meet the legal standard, opposition to war in any form. He will be investigated. His friends will be interviewed. His commander will write a recommendation, almost certainly negative. His application will go up the chain of command, and at each level, someone will have the power to deny it. The statistics are bleak. During the Iraq War, the approval rate for conscientious objector applications in the Army hovered around 50%. In the Marines, it was lower. Many applicants were discharged, but not honorably. Some were court-martialed for refusing orders while their applications were pending. The young man in the recruiting office will spend the next year in administrative limbo. He will be reassigned to non-combat duties while his application is reviewed. He will be called a coward by some of his fellow soldiers. He will be praised by others. He will lose friends. He will find new communities, networks of veterans and activists who believe that conscience matters more than contract, that the right to refuse to kill is more fundamental than the obligation to serve. His application will eventually be approved and he will be discharged, but the discharge will not be honorable. It will be under honorable conditions, a category that sounds fine but carries consequences. Reduced veterans' benefits, difficulty finding certain jobs, a permanent mark that he did not fulfill his obligation. He will spend the rest of his life explaining himself, justifying himself, wondering whether he did the right thing. You are standing now in a different kind of courtroom, not a criminal court, but an employment tribunal in New York City. The year is 2019. The case involves a pharmacist who has refused to fill prescriptions for emergency contraception. She claims that doing so would violate her religious beliefs, which hold that life begins at conception and that emergency contraception is a form of abortion. She has been fired, and she is suing for religious discrimination. Her employer argues that she has no right to refuse. She is a licensed professional. Her job is to dispense medication, not to judge the morality of her customers' choices. If she cannot fulfill the duties of her position, she should find another line of work. Her attorney argues that this is conscientious objection. She has a sincerely held religious belief that forbids her from participating in what she sees as the taking of life. The law, he says, must accommodate her, just as it accommodates the soldier who cannot fight, the doctor who cannot perform abortions, the clerk who cannot issue marriage licenses to same-sex couples. The tribunal will have to decide whether conscientious objection, which began as a doctrine about war, has expanded to cover other contexts: healthcare, employment, public service. And if it has, where are the limits? Can a police officer refuse to arrest someone for a law he believes is unjust? Can a judge refuse to sentence someone for a crime she believes should not be criminalized? Can a teacher refuse to teach material that contradicts her faith? The doctrine is stretching again, but this time in a different direction. It is no longer only about the right to refuse to kill. It is about the right to refuse to participate in anything that one's conscience forbids. And the law is struggling, once again, to find the line between protecting conscience and allowing social functioning, between respecting belief and preventing discrimination, between individual rights and collective obligations. You are standing in a quiet room now, late at night. There are law books on the shelves. There is a window that looks out onto a dark street. You are reading a case, and you come across this sentence from a dissent by Justice Douglas in the Gillette case. The law does not require us to do something that our conscience finds repugnant. You pause. You read it again. It sounds true. It sounds like something the law should say. But you know, from everything you have just witnessed, that it is not quite accurate. The law sometimes allows us to refuse what conscience finds repugnant. But only sometimes, only in certain contexts, only if we can prove our sincerity, only if we can show that our beliefs are deep enough, systematic enough, long held enough, only if we object to everything, not just to this. The law protects conscience, but warily, grudgingly, with many conditions. And you wonder whether that is because the law is wise, knowing that conscience can be manipulated, exaggerated, claimed falsely by those who simply do not want to do hard things. Or whether it is because the law is afraid that if it truly honored every conscience, every deeply held belief, every sincere objection, the whole edifice of social order would collapse, and we would be left with nothing but individuals, each following their own moral compass, accountable to no one but themselves and whatever God or principle they serve. You sit with that question. You do not have an answer. Neither, it seems, does the law. You are standing in a field again. Not the same field. This one is in upstate New York, in autumn, the leaves turning red and gold, the air smelling of wood smoke and apples. There is no army forming here, no war about to begin. But there is a young person, perhaps 17, sitting under a tree, thinking about the future. They have just registered for selective service, as all young people assigned male at birth must do when they turn 18. The draft does not exist anymore. It ended in 1973, but the registration requirement remains, a vestigial structure, a just-in-case maintained by a government that does not expect to need it, but is unwilling to let it go entirely. The young person is thinking about what they would do if the draft were reinstated. Would they serve? Would they object? They do not know yet. They have not had to decide. But they are aware that the law allows them to object if their conscience someday tells them they must. This is what conscientious objection has become, not an active practice, but a latent possibility. A door held open even if few people walk through it. The doctrine remains in the statute books, in military regulations, in the case law. It remains available should it be needed. But it has receded from public consciousness. Most Americans do not think about it. Most do not know it exists. The wars of the 21st century have been fought by volunteers, and the volunteers, by choosing to enlist, are understood to have waived their right to object. The legal battles now are not about refusing to fight, but about refusing to participate in other things: medical procedures, business transactions, administrative functions that conscience also reaches. The words conscientious objection have migrated. They are no longer only about war. They are about abortion, about contraception, about vaccines, about same-sex marriage, about education. The principle that the law should respect sincere moral conviction, even when that conviction leads to refusal, has been unmoored from its original context and set adrift in a culture full of moral disagreements, each side claiming conscience, each side demanding accommodation. And the law, once again, is trying to find the balance. It is trying to decide when conscience is genuine and when it is pretextual, when accommodation is justice and when it is simply privilege, when protecting the objector serves freedom and when it harms the person whose rights the objector refuses to recognize. You are standing in that field, watching the young person under the tree, and you are thinking about what conscience is. It is not, you realize, a simple thing. It is not a voice that speaks clearly, telling you what is right and what is wrong. It is more like a sensation, a tightness in the chest, a resistance in the body when you are asked to do something that feels like a betrayal of who you are. It is the feeling of being unable to proceed, not because you lack courage, but because proceeding would require you to become someone you cannot recognize. Conscience is the boundary of the self. It is the place where you stop, where you say, I cannot go further, because if I do, I will no longer be me. And the law, in recognizing conscientious objection, is recognizing that people have such boundaries, that there are things we cannot ask people to do without asking them to betray themselves, that some part of the self must remain inviolate, even when the state needs bodies, needs labor, needs compliance. But the law is also recognizing that these boundaries are not infinite, that if everyone's conscience became a wall behind which they could refuse anything, society could not function. That some claims of conscience are self-serving, some are convenient, some are really just prejudice dressed up in the language of deeply held belief. So the law draws lines. It says, you may refuse to kill if you refuse to kill anyone for any reason, ever. But you may not refuse only this war, only this enemy. It says, you may refuse to participate in abortion if you are a doctor or a pharmacist, but the institution that employs you may still be required to provide the service. It says, you may refuse to issue a marriage license if you are a county clerk, but someone else must be available to issue it so that the couple's rights are not denied. The law is constantly negotiating. It is constantly asking, how much can we accommodate conscience before accommodation becomes permission to harm? You are standing in a different room now, a law library, late in the evening. The books around you are old, their spines cracked, their pages thin and yellowed. You pull one down, a volume of Supreme Court opinions from the Vietnam era, and you open it to Welsh versus United States. You read Justice Harlan's concurrence again. He writes, having chosen to exempt, the government cannot draw the line between theistic or non-theistic religious beliefs on the one hand and secular beliefs on the other. Any such distinctions are not compatible with the Establishment Clause. You pause. You think about what that means. If the government exempts people from obligations because of their religious beliefs, it must also exempt people whose objections are secular. Otherwise, it is preferring religion over non-religion, which the Constitution forbids. But if the government must exempt secular objectors, then what counts as a secular objection? Political belief? Philosophical conviction? Strong personal preference? The law has never fully answered this. It has said that the belief must be deeply held, that it must occupy a place parallel to that filled by God, that it must be more than mere opinion. But these are vague standards. They require judges and administrators to peer into the minds of objectors, to assess sincerity, to measure depth of conviction. This is an impossible task. Conscience is internal, invisible, known fully only to the person who experiences it. The law can observe behavior, can listen to testimony, can weigh consistency over time, but it cannot see into the soul. And so, conscientious objection doctrine is, inevitably, imperfect. It protects some people who deserve protection and denies some who also deserve it. It is exploited by some who are insincere and fails to recognize some who are profoundly sincere but lack the language or the documentation to prove it. The law does its best, but its best is limited by the nature of what it is trying to judge. You are standing now in a courtroom one more time. The room is empty except for you. The lights are dim. The judge's bench is unoccupied. The witness stand is silent. You imagine standing there yourself, called to testify about your own conscience. What would you say? How would you prove that your objection is real, that it is not just convenience, not just cowardice, not just a way to avoid something difficult? You would have to tell the story of how you came to believe what you believe. You would have to trace the path your mind took, the books you read, the conversations you had, the moments when something shifted inside you and you realized you could not do what was being asked. You would have to make visible something that resists visibility. You would have to put into words something that exists beneath words. And you would have to hope that the judge believes you, that the judge sees in your testimony the same quality of conviction that is present in the Quaker who will not fight, the Catholic who will not abort, the soldier who has seen war and cannot see it again. This is the vulnerability at the heart of conscientious objection. It requires those in power to trust those without power to tell the truth about their own minds. It requires the state to believe the citizen. It requires the institution to accommodate the individual, even when the individual's refusal makes the institution's work harder. This trust is fragile. It can be broken by a single liar, a single person who claims conscience when they really just don't want to be bothered. And when the trust breaks, the law tightens, the standards get stricter, and the next sincere objector finds it harder to be heard. You are standing outside now. It is night. The sky is very dark, and the stars are visible in a way they rarely are near cities. You can see the Milky Way, a river of light across the black. You think about all the people across all the centuries who have stood where you are standing now and looked up at the same sky and wondered the same things. What do I owe to the state? What do I owe to my conscience? When those two things conflict, which one do I serve? The law has tried to answer this. It has said, usually you owe the state your obedience. But in rare cases, when the state asks you to do something that would require you to betray the deepest truths you hold, you may refuse. Not without cost, not without consequence, but you may refuse. This is a small accommodation. It is not a full protection. It does not prevent the state from punishing objectors, from imprisoning them, from marking them as having failed in their duty. But it acknowledges that conscience exists. It acknowledges that the state's power over individuals is not absolute. It acknowledges that there is something in each person that the state cannot rightfully command. This is, perhaps, the real meaning of conscientious objection. Not that the law protects the objector, but that the law admits the objector's claim is legitimate. That the law says, yes, there are things we cannot make you do, if doing them would destroy who you are. It is a fragile doctrine. It is an uncertain one. It is constantly challenged, constantly redefined, constantly at risk of being narrowed out of existence or expanded into incoherence. But it endures. Because as long as there are states that make demands, there will be individuals who cannot comply. And as long as those individuals speak, there will be a need for law to listen. You are standing in the field again, in the present moment, under the wide sky. The young person under the tree has gone home. The leaves are still falling. The air is still cool. You think about the man in 1776 who refused to take up arms against the king. You think about Daniel Seeger, who did not believe in God, but believed in something. You think about the soldier in Iraq who said, I cannot do this, even though he had promised he would. You think about the pharmacist, the clerk, the teacher, all the people who have said no when the world told them they must say yes. And you think about the judges who have had to decide whether these refusals were noble or selfish, principled or convenient, worthy of protection or deserving of punishment. You do not envy them, because the law, in the end, cannot see into the human heart. It can only listen to what the heart says and try to discern whether what it hears is truth. And sometimes it gets it right, and sometimes it does not. And the person whose conscience has been denied must live with that, must decide whether to comply, to resist, to accept punishment, to flee, must decide what it means to be faithful to oneself in a world that often requires us to be something other than who we are. This is the burden that conscientious objection law tries to address. It does not remove the burden. It does not make the choice easy. But it says, if you must choose between the state and your soul, the law will at least acknowledge that you face a real dilemma, not an imaginary one. That is not much, but it is something. And on a cold night, under a wide sky, with the weight of history pressing down on you and the future uncertain before you, sometimes something is enough. You are standing in silence now. The field is empty. The stars are bright. The story is finished, but the question remains. What would you do if you were asked to do something you believed was wrong? Would you refuse? Would you have the courage to say, I cannot? Would you have the faith that the law, or history, or something larger than yourself would vindicate you? Or would you comply, telling yourself that this is the price of being part of a society, that we cannot all follow our own consciences or nothing would ever get done, that sometimes we must do things we do not want to do because the alternative is chaos? There is no right answer, or rather, there are many right answers depending on the person, the moment, the demand, the cost. Conscientious objection is not a doctrine that tells you what to do. It is a doctrine that says, if you decide you cannot do what the state asks, here is a path you might take. Here is a claim you might make. Here is a chance, however slim, that the law will respect your choice. It is not a guarantee. It is not even a promise. It is only a possibility. But possibilities matter. They keep doors open. They allow for the unexpected, the courageous, the prophetic. They make space for the person who sees what others do not see, who refuses what others accept, who stands in a field in 1776 or 2024 or 2176 and says, quietly but firmly, "No, I will not." That person may be a saint or a fool. History will decide. Or perhaps history will never decide. Perhaps some refusals are too small, too personal, too ordinary to be remembered by anyone but the person who made them. But they matter to that person. They matter to the self that remains intact, the soul that was not compromised, the conscience that was honored even at great cost. And the law, in recognizing conscientious objection, is saying, that matters to us too. Not always, not reliably, not without conditions and caveats and burdens of proof, but sometimes. And sometimes is where hope lives. The field is very quiet now. You can hear the wind moving through the grass. You can hear, faintly, the sound of a car on a distant road. You can hear your own breathing. And you can hear, if you listen carefully, the echo of all the voices that have said, across the centuries, I cannot. They are still speaking. They will always be speaking. And the law, however imperfectly, is still trying to hear them.